we'd like to welcome everyone to today's webinar, Delivering Justice Virtually, COVID-19's Impact on Legal Matters. Just a little bit of housekeeping items today. So if this is your first time using GoToWebinar, you can dial in either by your telephone or you can listen through your computer. We will be taking questions throughout, so you'll see that there's a question box in there. Feel free to type in your questions. We're going to answer as many as we can at the end. If we don't get a chance to answer your question, we're definitely going to send them to everyone afterward, and then they'll send you an answer once the webinar is completed. So feel free to put them in, don't hesitate. I know there's a lot of information to cover in a half hour given all of the changes that have been taking place. With us today, we have panelist Judge Hanny Mala, who is a judge on the New Jersey Superior Court in the Appellate Division, Part D. We also have today Alex Chrisnomowitz. Alex is a member of Smolin Lupin and a licensed certified public accountant in New Jersey with over 15 years of experience. We also have Henry Rinder, who will be moderating today's panel. Henry is a licensed certified public accountant in New Jersey and New York with more than 30 years of public accounting experience. We also have Thomas Scrivo. Thomas is a managing partner at Oldsmith Scrivo. He is an experienced trial lawyer and a trusted advisor to clients in the public and private sectors. And last but not least, we have Josh Zielinski. Josh is an attorney at Oldsmith Scrivo who has a range of litigation and trial experience. And with that, I will pass things along to Henry to get things started.
Thank you very much, Amanda. We have assembled a very knowledgeable and skilled panel for you today to discuss the options in terms of judicial resolution to conflicts and disputes. And we will talk about what options are available under the current circumstances, having to deal with the coronavirus and so on, to plaintiffs if they want to move the cases. We're going to talk about how courts are adapting to this changed landscape and using virtual technologies. We will also address the pros and cons of arbitration and other alternative dispute resolution methodologies that exist in view of where we are today, and talk about depositions and other discovery methods that are available to lawyers in today's situation. And finally, we'll address what to expect in near future for resolution of legal matters. With that said, I'm going to turn over to Judge Mala, who will address the perspective from where he sits. Judge?
Thank you very much, Henry. Good afternoon, everybody, and I want to preface my remarks by wishing you and your families well. I hope everybody's well during this rather unique time. My task is to cover from the court's perspective what we've been doing to address the challenges that have been raised by the coronavirus. Before I get into some of the details of the Chief Justice's omnibus order, I do want to point you to the court's website because there's a lot of stuff out there that you might be getting from your local bar associations, which is very helpful. But you should also know that the court maintains a live web page that has on it the most current orders issued by the court addressing this matter. And you can find that at njcourts.gov/public/COVID-19. So what I'm going to be discussing is the omnibus order, which many of you know already. The order is rather detailed, so I'm only going to highlight a couple of things from it and then turn matters over to Tom and Josh, who will provide their valuable insight. The second order is the latest order, which is the April 24, 2020 order, following up the initial one that the Chief Justice issued on March 27 in response to the state ostensibly shutting down. What is not shut down, and what is, I'm sure, obvious to you by now, is that the courts continue to function. It's just that virtually all of the court's employees, not just judges, but the staff, have been transitioned to working remotely. The omnibus order speaks to very important deadlines which you should be aware of in your practice. The extension of discovery through May 10, and giving a special extension for discovery dealing with medical professionals because they're on the front lines of battling COVID to May 31st. The order puts a halt to jury trials and grand jury proceedings at least through May 31, and may in fact be extended beyond that. And most importantly, with respect to your practice away from the court, the orders, while suspending court proceedings, certain court proceedings such as trials and jury trials, extends discovery and extends other very important deadlines. As you know, the statute of limitations is just that. It's statutory. It's an animal created by the legislature, and so the court, due to separation of powers issues, can't be in the business of modifying the statute of limitations. But the court managed to work around what can sometimes be a rather cumbersome process in the legislature when the Chief Justice, in this order, declared a legal holiday through May 10, ostensibly tolling the statute of limitations. And obviously, if the emergency extends beyond that, and I would not be surprised if it does, it may result in the court extending that legal holiday. That statute of limitations is on all matters, but also including services of notice for tort claims against governmental entities. The municipal courts, because as you know, in the municipal courts we have I'm pretty sure I'm accurate when I say to you we have about 539 municipal courts in the state, each one having different capabilities. The municipal courts were a little slower to transition because there's so many and because their needs are so different. And so what the omnibus order does is it gives the municipal courts more time to make that transition by suspending their operations and giving them more time to make that transition to an online platform. However, if the parties consent, that deadline that's in the Chief Justice's omnibus order can in fact be ignored, and the parties can proceed if the court and the parties have the ability to do things remotely. The order also speaks to depositions and encourages the fact that discovery should continue in your cases, that because of COVID, it does not necessarily mean that your discovery ceases, but instead that depositions should be conducted by video. And obviously, the judges are available to you pursuant to the rules of court in the event that there's an objection to conference the matter and make a ruling for you on your deposition issue by way of telephone or by way of video. We're going to talk about that later on when we deal with access and fairness. The future of how things are depends on the progress or lack thereof against the virus, and also our ability, both the court and the bar's ability to do things remotely, or if we're going to do things in person, to do them safely. I'm prepared to move on to the next slide. I don't know if Tom or Josh, you want to chime in on anything?
Judge, this is Tom. I think might be best to go into that next slide, and then we can have some engagement after that one. I think be best.
Okay. All right. Thank you. All right. So our next slide talks about Jeds. I will tell you from a personal standpoint that prior to the coronavirus, I had no idea what Jeds was. I sit in the appellate division, and we've been operating with e-courts since 2013. As you may or may not know, the civil part got e-courts in 2016, and the foreclosure court got it in 2017. Jeds, I would say to you, is a companion software to e-courts. The purpose of Jeds was primarily to serve self-represented litigants and those attorneys who aren't on e-courts, to enable them to file things with the court remotely. Attorneys, obviously, as I indicated earlier, can use it for items that they can't file in e-courts, but the court has been very clear that if you've got e-courts, the court wants to see attorneys push all their matters to e-courts, and that's inclusive even of orders to show cause. What's nice about Jeds is if you've got for filing fees, if you've got, I call it the JAX account, your electronic account that you pay your fees through, you can link it to Jeds. And so the courts have allowed that flexibility for attorneys as well. Obviously, self-represented, that's a different ball of wax. They are generally paying by way of credit or debit or the other means that the system permits. Documents. Jeds is capable of handling a significant amount of documents. 35, and you'll forgive me if you already know this, but again, it's helpful to emphasize to you the amount of documents that Jeds can take. 35 megabits or megabytes, translates to, if you're doing the math, 10 megabytes is about between 400 to 500 pages of PDF documents. So it's safe to say that the majority of your motions are going to fall well within that parameter, because 35, if my math is correct, and that comes out to about 1,750 pages of material that you can upload onto Jeds. So it's a pretty flexible and a dynamic software that the courts put together, in addition to the fact that you can upload JPEGs and in addition to PDF and also DocX pages. One thing that you cannot upload, and this is important because in the trial court I recalled getting recordings from people, whether they were on a zip drive or on a flash drive. That's one thing that you cannot upload to Jeds. So that's an important thing to note. I would say to you that in that regard, reaching out to the court and finding a way to hand deliver physically a flash drive or an audio that's on some sort of other method or media recording is a good way to get around that one issue with Jeds. This electronic platform, whether it's Jeds or eCourts, I think is a harbinger of what's to come, meaning that regardless of what happens with coronavirus, the virus has hastened the advent of not only remote proceedings, but also the judiciary's scaling up of using software to handle cases, the cases before it. It's hastened the arrival of eCourts to the family part, and you family practitioners, you matrimonial practitioners out there should be cognizant of that. But it is also imposing those same obligations on self-represented litigants. Obviously, there will still be a subset of litigants that will be required to file things, that can only file things in hard copy. But my message to you is that I think a lot of this is going to be around for the aftermath of Corona. Those are, for now at least, my initial comments, and I'll defer to Tom and to Josh.
Hey, Judge, this is Tom. Thank you very much for that overview. It's obviously extremely important to all of us who practice in the courts. For Josh and I, we practice predominantly in the civil courts, and as you mentioned, have been involved and have been using eCourts, for the last many years. One of the things about Jed that is now coming into the fore is its use in the general equity part. Josh and I spend a lot of time, and obviously Henry and Alex do as well in terms of expert work in the general equity part and in the Chancery Division. And for those on the call who are aware, there was not eCourts in the general equity part. And now they're moving and migrating toward Jeds. And we have several cases now where Jeds is being used for filings in general equity in the Chancery Division. So as you just said, Judge, this is all hastened e-courts and filings and everything else, and we're seeing that now in the general equity part as well. It's actually a welcome addition for us practitioners who have been still having to file things in Chancery the old-fashioned way. So that's something that we've had filings this week on, and it's obviously the court's response to just another of the court's response to the coronavirus.
Judge, could you take on the next couple of slides and then talk to us about access to the bench and the alternative dispute resolution options?
Absolutely, Henry. This is Josh Zielinski. First of all, thank you for putting this together this afternoon, Judge Mala. It's a pleasure to be with you and the other panelists, and I hope all of you and your families are doing well. As the judge and Tom have indicated, with technology and with e-courts, there is access to the courts, and the courts are functioning. There's a common belief and myth right now that the courts are not functioning, and certainly in the civil courts, they're functioning and functioning very efficiently. In addition to the two omnibus orders that have been issued by the Chief Judge, I think it's wise for all practitioners to also take a look at Directive 1220, issued on April 27th by the Administrative Office of the Courts. In that directive, the courts are moving all parties as much as possible to doing remote and video or teleconference hearings. Importantly, they set forth 6 matters that will proceed remotely on consent only, and those concern primarily criminal, family, and incapacity hearings. Otherwise, the directive provides that matters will proceed remotely with or without consent. Early on in the coronavirus, back in March and early April, many parties in civil matters were stating they had a right to a hearing live in court. I think that as this lingers and continues, more and more pressure will be put on litigants and on the courts to move the civil calendars and to move them using the remote means that are available to them. So, and we've had this happen recently in some matters that have been tried on bench trials where the judges have said, all right, if this continues in June, be ready to proceed remotely. Load your documents up and get them to the courts. If you need a temporary restraining order, as Tom indicated, you can get in touch with the Chancery courts. You can now use the Jeds systems, and there have been Chancery hearings being conducted, weekly and daily by the court system. Judge or Tom, is there anything you'd like to add?
I'm happy to add after Tom. I don't know if Tom has anything else that he wants to put.
Yeah, I'm fine, Your Honor.
Yeah, I would follow up both Tom and Josh's comments. Directive 1220 is important because it highlights what we've been talking about so far today, and that is that the court has put at judges' disposal a myriad of software that you should look to invest in. And when I say invest, I'm not talking necessarily about having to purchase anything beyond a computer or a tablet or whatever platform you're comfortable using, but really to get as much of the software that's out there as possible because the judges have it. So what do the judges have? And Directive 1220 speaks to some of the things that the judges have. They have access to Microsoft Teams, which is a very secure platform and is actually quite dynamic. They also have access to Zoom. You've heard about Zoom in the news and whatnot. They have access to Scopia. And interestingly, the Directive 1220 says phone. So obviously, when it says when the court's talking about phone, I'm talking to you through a phone right now, but it's also it would not necessarily be a no-no to participate in a hearing using FaceTime if it's appropriate, if the judge approves, and if the parties consent. So there are a myriad of platforms out there, and you should embrace them. You should download them to whatever device you're using and play with them. That's what I do because I like to know these things before I find myself in a situation where I have to use it and don't know how. One thing you should also know is that all judiciary employees, so now I'm talking beyond judges, all judiciary employees have access to Zoom. So that's sort of the standard platform. And another thing you should know about these platforms is you can present documents on them. So if you find yourself in a situation where a hearing or a trial or something of an evidentiary nature, or even on a motion, where a judge is asking you a question about a document and you need to discuss that document with the judge, all these platforms will allow you to present the document on that common platform so that everybody is looking at the same thing, and that you can walk the tribunal or the witness or who have you through your presentation. So these are rather dynamic software platforms that we're dealing with. And one thing that the chief has been very clear about, whether it's in reading his orders or in his instruction to judges, is that in this time, at least while the virus continues to do what it's doing, the court will be flexible with you. It's just a matter of asking and seeing if you can gain your adversary's consent, and giving the judge the heads up, him or her the heads up. The court will be flexible with you in terms of moving your matter forward.
Hey, Judge, this is Tom. Just a question. All of us involved in the system note that some of the judges are conducting Zoom conferences regularly that are viewed on the court website, that anyone can kind of watch, and several are not, and then some are dealing with things by phone. How much flexibility has the Chief Justice given to the judges to conduct these conferences, motions, et cetera, as they wish?
There's been a tremendous amount of flexibility given, specifically to the parties and counsel in the individual cases. What you touched upon, Tom, is I think even a broader issue, and that's covered by Directive 1120. And again, you can find that on the web page that I gave you, the court's web page. Directive 1120 drives at the heart of access and fairness. I sit as the vice chair of the Supreme Court Committee on Access and Fairness, and as you can tell from the title of the committee, the goal is to make sure that we operate an open court system. There are obviously some limitations. So, for example, third parties aren't going to be invited to a matter involving DCP&P, and Directive 1120 speaks to that to a certain extent. In other words, there are things that occur in open court. However, if we're talking about discussing something that's confidential, whether it's revealing a bank account number or a driver's license number, or if it's a matter that is essentially closed by statute, such as a DCP&P matter, a child welfare matter, obviously the judges adhere to those rules and can exclude third parties. In the appellate division, and we're going to talk about this a little later, but we had oral arguments in the appellate division on Wednesday, and it was I believe it was an LAD case that was on appeal, and a member of the press called in and listened, and that's because had we been sitting in Jersey City or Morristown or wherever we would have heard argument on Wednesday, had there not been coronavirus, that person could have sat in the back of the courtroom and taken notes without any issue. So the courts remain open. It's just a question of, and this is what Directive 1120 speaks to. It's a case by case basis in terms of the court addressing any concerns that the parties may have regarding who's listening in or who's dropping in on the call or the video conference.
Josh, could you take a lead on the next slide?
Oh, absolutely, Henry. So the purpose of the webinar this afternoon is not to discuss in detail the extensive differences and pros and cons of trials and arbitrations. We could spend hours going through that. What it is intended to cover, though, is trials and arbitration in the COVID era that we have right now. The common misnomer, again, is that the courts are not operating. While jury trials are suspended, plenary hearings are moving forward through the use of Zoom, through the use of Teams and other platforms that are available to the court system and to the litigants. Additionally, bench trials are moving forward. So the court system is open. The court system is available. Alex and I were speaking the other day, and they had heard advice that parties in commercial disputes should get to arbitration as soon as possible. I don't necessarily agree with that point of view. Again, the courts are open, and even if you choose arbitration, you still have to retain a person, a human being, to adjudicate that dispute. Second, arbitration is often extraordinarily costly. The court system is funded by our tax dollars. Depending on the size of the arbitration panel and who you retain, the costs associated with arbitration can be significantly an added cost to civil litigation, which is already very expensive. And then finally, there's also a notion that arbitration is faster, and that, in my experience, has proven not to be the case. Certainly, if the parties can reach an agreement on the speed with which they want their matter resolved, it can move quickly. But if an agreement cannot be reached, there are some instances where arbitration may take longer for a matter to be adjudicated, because you'll have to coordinate everybody's schedules and times if they're not willing to consent. So that's kind of an overview. I think right now with the COVID world, I think the court system is a good alternative for parties that have a dispute, particularly if you can reach consent with your adversary with the flexibility that judges have. They have the time, they have the means to handle your dispute. Tom, what are your thoughts?
Thanks, Josh. Yeah, I think the issues I think we're facing now aren't really trials versus arbitrations. I think they're jury trials versus bench trials. We've got a couple of advice from several of the presiding civil judges who have had similar webinars and advisories out of their chambers with respect to providing the parties with the opportunity to waive down to bench trials, so that when the courts reopen, even if jury trials are still being suspended, because I think, and I'm not so sure, Judge, you'd be interested in your thoughts on that. I'm not so sure that the jury trials, that the courts are going to have the facilities to be able to conduct the jury trials once the courtroom doors are reopened. But we're getting requests from the presiding civil judges to see whether we would be interested in waiving jury trials, because clearly the trial judges want to move cases. And so particularly in some of the commercial disputes that we have, it maybe not be necessarily for personal injury cases, but for the commercial disputes we have, the choices that clients will be given now are potentially getting a trial before a judge in 2020, and one that they would have to wait well into 2021 and perhaps longer for a jury trial. So these are the questions that clients are going to ponder and counsel are going to ponder with their clients over the next ensuing months. And I just don't know if the courts structurally are going to be ready for jury trials anytime soon, Judge.
Johanna?
Yes. Well, I mean, the issue of resuming jury trials is a complicated one, and I think you can take a page from the sports world in that regard. I mean, I was on the news yesterday. They were talking about, I forget which franchise it was, but there's a franchise that is looking at resuming, public attendance for its games. Stadium can take 60,000 people, but with social distancing, they're going to admit 15,000 people. So 60,000 people cheering versus 15,000 makes a decent difference, pretty big difference. But I use that as an analogy, or to perhaps draw an analogy to the court. Obviously, social distancing, absent the advent of rapid and readily available testing and a vaccine, social distancing is going to be a facet of the way jury trials are conducted if they resume. But also, using the analogy of 60,000 fans versus 15,000 fans, jury pools are going to be, I think, compromised to a certain extent, where, if you don't have the space to bring in 200-300 people to sit and potentially be selected for a jury, it may end up being more than one day to pick a jury. Well, certainly more than one day, but it may be even longer than that to pick a jury for your case. So I tend to be optimistic And I don't want to say that that jury trials aren't going to happen in the near future. I just think that it will be, compromised in that way. And I do think that, in the standard questions that are asked during the voir dire, there may need to be something that addresses COVID. I don't know what that looks like. I don't know if it's asking, are you comfortable sitting with the folks in close quarters, or obviously you can't ask somebody about their medical condition, but that may be another facet of the questions that get asked, and that also will cause a lot of people to beg off, I think, of jury service. But by and large, again, when I sat civil, by and large, the folks who showed up and who answered questions forthrightly, those are the people I wanted on my jury anyway. And those folks were willing to tough it out. Obviously, we didn't have Corona, but they were willing to put a lot of things on hold to fulfill their civic duty. Going to Josh's question, I'm a bit of a split mind on this, in that I agree with him that our judicial system is taxpayer funded and should serve you and should serve your clients. On the other hand, there is legion of case law from the Supreme Court who I would not dare on this webinar shirk that speaks of the benefit of arbitration. So I would say to you that that's a decision your clients make, whether or not they hold out for a jury trial or proceed to a bench trial or proceed to arbitration. That's a decision your clients make. And I think Josh did a wonderful job of explaining the pros and cons.
Thank you, Joanna. As we switch focus to experts, Alex Krasnamowicz and I serve the court system as forensic accountants, as forensic experts, and we also are encountering some of the difficulties brought upon us by COVID-19. And to that point, on the next slide, we listed some concerns. Amanda, can we switch? And Alex, can you please address them?
Certainly, Henry. Thank you. So many of the challenges we're facing as experts aren't necessarily unique to us at this time. They're shared with other areas serving the court, but one of the biggest issues remains communication, reaching counsel and clients with everyone's unorthodox work schedules. Find myself working earlier in the morning and later at night with 4 children at home. Many of the people I'm dealing with daily are managing the same. Sure, the work gets done, but sometimes it has to be at off hours. Along those lines, as experts, we're very accustomed to dealing with very large amounts of financial data. So we take that data in, we organize, we query it. So now we're dealing with limitations on bandwidth in querying that data, and the time of day actually matters. I wouldn't recommend running queries on large amounts of financial transactions when everyone sits down to sip their tea and watch Netflix at night. You're just not going to get the results you're accustomed to when you're at your desk, hardwired at work. Collaboration among teams. So forensic and valuation engagements are largely team-driven. So you're managing different aspects of the engagement, and one person could be doing research, one person doing financial analysis. So delegating and connecting with staff and partners, again, unorthodox work schedules is presenting issues. So what we're doing is we're scheduling hard times to meet. But again, those times are subject to disruptions because all of a sudden a judge becomes available or a lawyer becomes available, and boom, there goes that internal conversation that was supposed to happen. Depositions. So I've attended a handful of Zoom depositions thus far, where I haven't been deposed myself yet since COVID, but supporting these depositions, and where you're usually sitting next to counsel, maybe passing post-its for follow-up questions on financial matters, now becomes another format, something predetermined with the lawyer. Are you going to be texting them as you're witnessing the deposition? Are you sending emails? Certainly creates issues and has drastically affected the flow of depositions I've been involved in. I've seen arbitrators limit testimony to blocks of time with breaks in consideration of people's childcare and various work schedules. Along those lines with arbitrators, I've never heard so many threats of counsel on behalf of their clients threatening appeals due to the fact that an arbitrator is asking counsel or the client to do something at a time they don't want to do it or in a way they don't want to do it, all by and among COVID. And I just wanted to touch upon much of our practice is related to valuing closely held entities. And so in the wake of COVID, and as we're living through this, the business valuations that we have in process, we're now having to reconsider. And we're asking ourselves, how are these stimulus funds affecting this business as a going concern? Is limited activity going to change the landscape for this business permanently, or are these one-off? And consider of all these things, it's definitely affecting our work. Henry, have you been deposed in the wake of COVID? Like I said, I have not yet.
No, I have not, but I have previously been deposed in depositions which were taped with a professional videotaping equipment. And I also set in on depositions of other witnesses with a similar kind of setup. And I can say this with certainty, that professional video conferencing is a lot different than Zoom, where the setup is put together in such a way that the examining attorney, number one, is sitting there, so he can observe the body language. And even if he's not sitting physically in the same space, the setup gives him a much better sort of point of view of the witness in observing the body language. I'm not sure whether that can be accomplished easily with these different alternative video conferencing applications. And going back just, Alex, to our difficulties, obviously in business valuations, one of the procedures that we utilize is what's called a site visit. And needless to say, it's almost impossible right now to imagine that you have that ability in most businesses. Also, walkthroughs of transactions in fraud cases or allegations of fraud, where we actually go on site and try to trace through transactions within the company, within the system. That's probably not going to be possible, and we as experts will have to either come up with workarounds dealing with these requirements, or qualify our reports to say that we are simply unable to complete these kind of procedural processes. I think we are kind of running out of time, so I want to speed up the process a little bit. I'm going to turn over to Tom to cover our last slide on the appellate division. Tom?
Sure, and the judge spoke briefly about the oral argument earlier. Obviously, one of the great thrills of practicing law is to be able to participate in oral arguments before the appellate division, and just obviously, and as a credit to the Chief Justice and the AOC, that appeals also, like civil matters in the trial court, are moving as well and continue to be processed and move along. However, it's slightly different to be able to read the bench, so to speak, to the extent you can, and to be able to respond in real time to adversaries' arguments that where you might be reserving time to respond. These are all issues that hopefully will be back live in the appellate division soon for oral argument, and in the Supreme Court as well. so that things can resume back to the way they were. But really, this slide is tends to geared toward the judge and to maybe for some observations as to how the court is handling oral arguments by phone and what that impact might be on the collaboration among the judges as you work through preparing opinions.
Tom, I think really hit on the important aspects. This transition, as a result of coronavirus, has been the least interesting as far as the appellate division is concerned, and that's because we were already doing much of our work remotely. As I indicated to you earlier, we've had e-courts since 2013. The appellate division doesn't operate courtrooms on a daily basis. We have oral argument once a week, 3 weeks on, 1 week off, depending on the individual judge. And so the only thing that required brick and mortar really was the oral arguments. And Tom is absolutely correct that there is a facet of the oral arguments that's lacking. The appellate division has not been assigned Zoom capabilities, although all of us have Zoom and Teams and all that, as I told you earlier, but we haven't been doing our arguments through Zoom and Teams because there's been an effort to conserve the bandwidth that the court has that's been allocated really to the trial courts because they're the ones that require it more than we have. But we've been doing our arguments on telephone, and as you know, the appellate division is not a court of record. So what we say during the oral arguments is not evidential in the event you seek to petition the Supreme Court for certification. However, because we operate in an open courtroom system, our oral arguments are on CourtSmart. And so beware of that because what you say is recorded. It's not evidential. What we say is not evidential, but again, it's recorded. And so it's not a casual type of atmosphere. You're still in a courtroom. And the oral arguments that I've participated in have been quite professional, both in terms of the bench and the bar. The thing that I miss, and Tom touched upon it, are the verbal cues. Like, when I can jump in and interrupt an attorney has been made a lot more difficult when I can't see that attorney's face. So I've resorted to waiting for the attorney to finish argument, and then usually the presiding judge will ask the judges if the judges have questions, and then that's when I'll ask the questions. So I'm not saying all panels operate that way, so still be prepared to be interrupted. It's a bit unsettling because you're on the phone and you're not expecting it to come because you can't see the judge who's just about to open his or her mouth, but beware of that. As far as collaboration amongst the judges, as I indicated earlier, we were doing a lot of our work remotely anyway. As you know, before oral argument, we exchange our opinions by way of informal memos. We continue to do that, and so that hasn't changed. And we conference matters either both before and after oral arguments. We do that, of course, separately on our own time. So that hasn't changed much. But as with this entire crisis, it's been the lack of human contact that one most regrets. And I for one, am hoping that we return to a sense of normalcy.
Thank you, Joanna. As we switch over to the final slide, we usually have time left to take questions. Unfortunately, we have run over our allotted time. So as we've done in the past, the audience posted questions on our chat. We will circulate those questions to the panelists and leave it to them to answer to the audience directly. I just wanted to thank our panel. This was even though we went over, this was so worth it. Fabulous presentations. I thank Joanna and Tom and Josh and Alex. You guys did a tremendous job. Really appreciate it. And Amanda, thank you so much for hosting it. And thank you to the audience. Stay healthy and stay safe. Have a good day.
Take care.
Bye-bye. Thank you, Henry.